From the minutes, item number 1.
May it please your lordship.
You looked into the case diary?
On perusal of paper book and the case diary, my lord, I feel that the filing of supplement paper book or additional paper book is required, my lord.
For what purpose?
The statement of Pilgrim 1 is different from the deposition in trial court, my lord.
I will not insist on any matter being done now, so you want to run away, you can run away.
No, my lord, I'm not run away.
Leave to file a supplementary paper book, full stop, comma, such supplementary paper book incorporating parts of the record of the trial court that have not been included in the original paper book, comma, should be filed within a fortnight from date. The matter will appear 4 weeks hence. All three are the same?
Yes, your lord.
all
1,
same.
2, 3.
From the minutes, item number 1.
We had required you to report on the facilities available in Shillong and in Tura, Jawai, Nongstown and Nongpo.
Please, Lordship. Lordship, please create a link to court room some more time.
Since the state seeks some more time to report on the facilities for burial and cremation in the major cities and elsewhere in the state, let the matter appear a fortnight hence.
Item number 2.
May I please, Your Lordship? The road from 0 to 32 is quite okay, my lord, after repairing. From 32 to 41, now some portion, 3 to 4%, it is not possible to ply this small vehicle, my lord. And from 41 to 51, my lord, 10 kilometer, there is 2-3 place. Petrol was formed. So a small vehicle is very difficult. Then from 67 to 100, my lord, there is also 2-3 places. So I pray that at least some gravel should be put so a small vehicle can ply.
So in compliance with the earlier order, ground study was being done. Thereafter, in segment-wise project, we have prepared we have placed the detailed project report to the authorities concerned for. We have also quoted the money required for approval. And in the meantime, also 33 to 41, we have deputed 3 numbers of contractors and they are doing the repair work. I have got a status report here, along with photographs.
Your this status report is by PWD.
Also,
The state PWD, you filed it? Yes. File the status report. According to the state, the PWD bracket roads in Tura has submitted a detailed project report together with cost estimates for the maintenance and repair work of the entire AMPT road. Full stop. The exercise has been done segment-wise, segment-wise paragraph. The petitioner reports that up to the 32-kilometer mark, there can be no grievance, but between the 33 km and 41 km, but not between. In the 31 km to 41 km stretch, 33 km to 41 km stretch, several potholes and bad patches have surfaced. Full stop. The same is reported till kilometer 61. Full stop. The petitioner also says that from kilometer 61 to 117.
Yes, my lord, 51 to 67, it is okay. 67 to 100 kilometer, my lord.
200 and?
67 to 100 kilometer, there is some
Very
problem
well.
also.
The petitioner says that from kilometer 51 to kilometer 67,
It is.
the road condition is satisfactory. But beyond that, until the 100-kilometer mark, there are several potholes that need immediate attention, particularly because smaller vehicles cannot negotiate the same. Paragraphs in this PWD bracket roads has submitted a report, and the AMPT road is a crucial artery, the state would do well to ensure that adequate funds are made available for the continuous maintenance and repair of the road to make it traffic worthy throughout the year. Full stop. Running repairs should also be undertaken during the monsoons, to the extent feasible. Full stop. Post monsoon, there should be a complete overhaul on a regular basis so that there can be vehicular movement without any great impediment. Paragraph. In view of the above and the several previous reports and the work done on the entirety of the MPT road, the present public petition is closed with liberty to both the petitioner and any other public spirited person to draw the attention of the court to the state of the road, if the condition deteriorates or if no immediate action is taken by the appropriate authorities. PIL 15 of 2018 is disposed of. There will be no orders as to costs. Thank you.
Item number 3.
May it please your lordship.
Yes.
Your lordship, first at the very outset we are tendering unqualified apology, my lord, because some confusion.
Why do you create a situation, Mr. Advocate, where you have to come
Yes,
and
sir.
apologize because of the wrongs that have been done? Why can a simple thing like an order not be complied with? How is it that people arrogate themselves so much authority over here that they think orders of court are a joke?
No, your lordship, it was a mistake on our part also.
It was not a mistake.
Your lordship.
Opening a commercial entity is not a mistake. It's
What has
deliberate.
happened, my lord? No, what has happened, your lordship has in one of the orders laid down the conditions that if those conditions are met and satisfied, and on the basis of undertaking, my lord, they will be permitted, my lord. That because of that order, if I can place that order, there was some confusion, but we have closed down.
After that, also there have been orders which says that the current status must be maintained till you put a system in place.
Yes, lordship.
Where everything, that system is not yet in place.
Your lordship, your lordship has said that 50 meters from the high flood level, my lord.
Yes.
So it was and it was beyond 50 meters, my lord.
And what about the effluent treatment? What about the effluent treatment?
So everything is, yes, your lordship, effluent treatment. In fact, there is no the wet kitchen, all dry waste, and everything is the pollution control
And
board
what
has
about
given the report. my lord.
the dry wrappers are thrown down into the water?
No, your lordship, we have collected
Has any environment clearance been obtained?
yes, your lordship, we have obtained the environment clear from
obtained
PCB,
environment
pollution control
clearance.
board.
For both of them, environment
Yes, your lordship.
clearance. Show us.
I have placed that report also, my lord. That report starts, my lord.
Yes, show us.
Page 17, my lord.
17.
Yes, your lordship. At page 18, my lord.
P18, yes.
And we have inspected and we have imposed the fine, my lord.
The matter has appeared several times after that. Why were we not informed that all this
Yes,
consent to
Lordship.
operate and all have been issued?
And your lordship,
There
if
are
your lordship
several
will see,
orders.
your lordship.
Mr.
Yes,
Advocate
Your
will
Lordship.
find there are several orders.
Yes,
Let's
Lordship.
see some of the orders.
Yes, Lordship. If your lordship will see, the first order in this regard is of 15 November 2022, my lord. 15th November 2022, where your lordship has taken note of this aspect.
Just a second. Come to the order dated 24th of May 2023.
Yes, Your Lordship.
On
That order
24th
says
of May,
that
we noticed that.
we allow any construction to come up.
No. Forget that. Even before that,
Yes, Your Lordship.
the state submits that the draft guidelines.
That
are
is, Your Lordship, on
circulated
2nd
for
February
comments.
2023.
We are looking at 24th of May
Yes, Your Lordship.
2023. The state submits
Yes, sir.
draft guidelines have been circulated for comments from various departments. At the request of the state,
Yes,
let
Lord.
the matter stand over for 8 weeks for a firm stand pertaining to the guidelines to be indicated. Now, have the guidelines now been
Yes, Lord.
finalized?
Yes, Your Lordship. That
Where,
has
where
been
is
filed
that?
and before Your
Where is
Lordship.
that? Where is that submission to court that the guidelines have been finalized?
Your Lordship will see that is the report filed on 19th July. 19th July, we have filed the report.
Yes. Now look at
The
the 19th
guidelines.
July order. The state has disclosed so and so by way of an affidavit. The guidelines do not deal with the most serious aspect of buildings and construction, mushrooming around water bodies. Though the guidelines
Yes, sir.
indicate that garbage, trash and debris may not be dumped, it is surprising that the guidelines are issued without indicating how far away from the high water level of every water body construction may be permissible.
Yes, Your Lordship. That guideline has been revised after Your Lordship's order, my Lord. On 25th August 2023,
Let us
this
see,
guideline has been revised.
where you reported that to the court.
Your Lordship
And you
has
see
taken
at
note.
the end of that order, paragraph 10,
Yes, sir.
paragraph 9, 8, in short, the guidelines of 2023 published by the state appear to be more of a formality without addressing the real issues. So we rejected it.
Yes, sir.
The state has to
Yes,
do
sir.
much better. A further report should be filed 6 weeks since the prohibition on construction around water bodies pursuant to previous orders will continue till the state addresses such issue in a more considered set of rules or guidelines. That was then.
Lordship, 19 July order was complied by 31st A
Just a
2000.
second. On 31st July,
31st.
Yes, Lord.
report has been filed by the state. So the petition is a copy of the. So the refurbished guidelines were never shown to the court
Yes, sir.
till 31st August. Then the matter next comes up
Yes, sir.
on 28th. So
Yes.
where have you, when the court is saying even on 19th of July that all this should not
Yes,
have,
sir.
do not have guidelines, where have you informed the court that you've given them consent to establish and consent to operate?
If I can show one order, my lord, what has happened, my lord, that your lordship has stopped prohibited further construction, my lord, and further construction. We wrongly construed, my lord, that the existing construction was permitted by your lordship's order of 15th November 2022, my lord.
We did
So,
not,
and then your lordship,
we required them, all of them, to
yes, lordship.
stop where they were for you to completely
we will
have a set of
comply.
guidelines, and then
Yes, sir.
in accordance with the guidelines to that. Your guidelines are not ready, and in the meantime you've given them consent to establish and consent to operate.
That was error on a mistake on our part, my lord. We will not allow unless it is approved by this court, my lord. Will not allow.
The state seeks to justify the functioning of a cafe. What is the name of the locality? What is that place called?
Maoyong Rim.
Maoyong?
Rim.
Maoyong Rim, overlooking the Umiam and close to stretches which serve as viewpoints over the Umiam. The state also seeks to justify one of the metal containers being made functional to dispense packaged food and drinks and the like. Full stop. Paragraph. A report has been filed today which reveals that as far as the cafe is concerned, the state environment control, what is it, board?
Meghalaya Pollution Control Board.
Meghalaya State Pollution Control Board.
The State Pollution Control Board initially granted a consent to establish and subsequently a consent to operate by setting down certain norms. Full stop. Doubtless, a similar explanation is there for one of the metal containers operating as a knick-knack store. Full stop. Several other metal containers installed over the last year, however, remain shut. Full stop. Most of the railings, both at such point and at viewpoints at lower levels, have given way or are dangerously or are in such precarious condition that a slight touch may result in its disintegration, but the state has chosen to take no steps in such regard. Full stop. Paragraph. The explanation furnished by the state is completely unacceptable since The orders of this court required guidelines to be prepared by an expert panel so that construction and activities in and around the water bodies, particularly the Umiam, could be regulated and controlled. Full stop. It is evident, paragraph, it is evident from an order dated May 24, 2023, that a set of draft guidelines was submitted in court. Full stop. Since the draft guidelines had been circulated to various departments for comments, the court granted time for the guidelines to be finalized. Full stop. The court also repeated the subsisting injunction that neither the state nor the local authorities will allow any construction to come up within 50 meters of the high water mark of the relevant authority without the express previous leave of the court. Full stop. Paragraph. This matter was next taken up on July 19, 2023. When the state disclosed the Meghalaya Water Bodies (Preservation and Conservation) Guidelines 2023, full stop. Upon going through such guidelines, the court observed that they did not deal with the most serious aspect of buildings and construction mushrooming around water bodies. Full stop. Later in the order, it was observed that the guidelines introduced by the state fell woefully short of the expectations or the measures necessary to protect water bodies, particularly the Umiam Lake. Full stop. At paragraph 8 of the order, at paragraph 9 of the order, it was observed that the state had to do much better, and a further report should be filed 6 weeks from the day or date of the order. Full stop. To boot, the prohibition on construction around water bodies was directed to continue, open quote, till the state addresses such issue in a more considered set of rules or guidelines that it frames. Full stop. Paragraph. It will be evident from the course of the present proceedings that the court was concerned not only with the construction around the water bodies, particularly the Umiam Lake, but the activities around the water bodies or near the water bodies also attracted the court's attention. Full stop. Specific orders had previously been passed in respect of the cafe and in respect of a further construction much lower down near the Chatwell pumping station. Full stop. On the other side of the road, automobile showrooms have surfaced and other business activities have also been permitted. Full stop. These also have an impact on the effluent discharged and reaching the Umiam waters, but the court concentrated only on the construction that was being undertaken on the water side of the road, including the installation of the metal containers right on the edge of the water. Full stop. It does not appear that at any point of time was it indicated to the court that despite the guidelines not being in place, the Pollution Control Board had purported to issue consent to establish and consent to operate to the cafe or to the other dispensing unit functioning from a metal container. Full stop. In other matters, the criminal failure on the part of the state to disclose material facts have come to light. Full stop. And so, the criminal act on the part of the state continues to deceive the court, obviously for extraneous considerations of those who run the government, and to have no regard for either the rule of law or the welfare of the citizens or to maintain the cleanliness of the environment. Full stop. Paragraph. In the clandestine manner that the state has gone about, deceiving the courts and granting permission, the court may have been excused into being lulled into inaction by believing that till the guidelines that the court required to be effectively prepared were in place, the state would not take steps behind the back of the court to altogether scuttle the purpose of the present proceedings. Full stop. Paragraph. Obviously, the court had more faith in the administration than the conduct of the administration deserved. Full stop. Paragraph. The specious explanation furnished by the court, by the state, is rejected. Full stop. Till such time that effective guidelines are prepared and presented before court for its approval to preserve the water bodies in the state, particularly the Umiam, no construction or commercial or business activity of any kind will be permitted that may endanger these water bodies. Full stop. Paragraph. Even today, there is no explanation or indication as to how the waste generated in the cafe or by the dispensing unit functioning from the metal container had been required to be dealt with, semicolon, or whether in the several months that the two have been functioning, whether there is adequate compliance in such regard. Full stop. The cafe juts out beyond the road level and hangs over the water, so to say. Anything which flows down from the cafe would go directly into the water. Full stop. The state cannot satisfy the court that any measure is in place to ensure that nothing flowing out from the cafe would contaminate or otherwise disturb the waters. Full stop. Paragraph. Much is the same about the dispensing unit from the metal container, which hangs out from the edge of the road and is directly over the water body. Full stop. There are 6 or 7 other containers down the road which do not appear to be functional, but which may enjoy the permission from the appropriate authorities. Full stop. Paragraph. It is also a matter of concern that despite land in the state belonging primarily to the tribals and tribal bodies, such bodies are careless in preserving the environment or protecting the action of the state or the Pollution Control Board in taking steps that have a potential to harm the people and the environment. Full stop. Paragraph. The matter will appear 10 days hence for the state to submit the new set of guidelines that ought to be in place. Full stop. Since the state says that the functioning units, meaning the cafe and the relevant dispensing unit from the metal container, comma, have been temporarily closed, comma, let such temporary closure continue till the matter appears next. Full stop.
Maybe please, Your Lordship. Your Lordship,
Yes.
earlier order was there, Morton garbage dumping ground, Your Lordship has suggested a state to look for another.
Everything we can't do, let's protect the water body also. We can't, the state also has its constraints, but this is not appreciated. This is direct deceit. In none of your orders from May, you tell the court you've done this. And this is not the first time. That's the way you function. You conceal letters from the union minister. Yes.
Item number 4.
Please. We have filed one affidavit on 29th, Lord.
What is this matter?
Lord, this is regarding that Barabajar.
What are you appearing for, Mr.
Lord, I am appealing.
No, central government is not a party in the present proceedings, my lord. The office of the Solicitor General just informed me, my lord, that central government has few points, my lord, in this matter.
The government is neither necessarily nor a proper party.
My lord,
Yes.
only two aspects, my lord. They informed me, my lord, this being a very communally sensitive matter, my lord, may flare up into a law and order issue.
Let it be. We'll take care of that.
So, Lord, sir,
We'll take care. You don't have to threaten us.
my lord,
We are not bothered by your threats.
my lord, only
We are not. Thank you. We are not giving you a right of audience. Yes, Mr. Advocate.
Lord, may I, with the kind permission, my Lord, may I humbly request, my Lord. In this matter, we have
You
filed.
haven't said that these people are going to create a law and order problem. We have enough space. We have enough space and authority to take that into control.
my lord, only one submission, my lord. What the ministry wants, my lord, that it can be settled mutually, my lord. Some more time can be given to them. That is the only concern.
They are just fooling around. Everything that the state government has offered them, they're fooling around.
But if necessary, central government.
Thank you.
Central government will intervene.
Ask the central government to take it over directly to the Supreme Court. Yes, Mr. Advocate.
Lord, may I humbly
Yes,
speak,
Lord.
Lord.
Yes.
Before my learned friend say something, Lord, because on 29th this matter was listed, my Lord, your Lordships were kind to give us some time.
Legal issue over here.
Absolutely.
Whether the order is justified or not.
We are so kind.
Writ court says that there are disputed questions of fact.
We are so kind, Lord.
We are happy with that. So go and file a claim in a civil court, get an order in a civil suit. The state will be bound by that order.
Absolutely, so kind, Lord. Only two submission, respectful submission, Lord, with your kind permission, Lord. Whatever has happened, Lord, we have filed this affidavit, page 13 of the affidavit, the minutes of the meeting, because your Lordships were so kind when the time was granted, both of us, so that this matter should not go in the litigation. It is better to settle the matter outside. We tried our level best and we are trying, Lord. They have also tried. The state is also very kind with us and has given a patience hearing on 13th of June, Lord. Kindly see 13th June. For a second, Lord, only 2 pages I'll show, Lord. We are in the hands of your Lordships, Lord. When on 13th of June, we went there. Lord, these 4 points were considered and these were noted down. These are the minutes of the meeting. Even I was present. I have signed, Lord. It was Mr. Amit, my learned senior, was also present. There were 4 points, Lord. First, to revisit the blueprint with the kind permission, may I read, Lord? So kind. To revisit the blueprint prepared by the state government and to make modifications according to the points raised by the Harijan Panchayat Committee in their response to the state government dated 20th of April 2023. This was the first point. Second, to examine the possibility of identifying another location in the European ward with larger area to accommodate the residents of the sweepers colony. And third was not to look into the proposals of accommodating the resident in the adjacent land belonging to the Shillong cantonment area and both sides to follow up with the Ministry of Defence. Now they have also followed up, we have also followed up. And fourth point was, it was also agreed to have more meetings on the same by both the parties so that this should be closed, my Lord. This submission, this issue, long pending issue should be closed, my Lord. And my Lord, with this we approached the Ministry of Defence. Even the Deputy CM of the government, he has also written a letter to the Ministry of defense, my lord, with a detailed submission that this land, adjoining land is required. The Ministry of Defense has also taken view. They said Joint Secretary will visit the premises, and it is mentioned in the letter, my lord, there in the letter. I couldn't get the copy because after 29th, 31st and 2nd, all 3 days were holidays. My lord, on 29th, after the direction of this honorable,
Yes.
my lord, one last.
Yes.
Just yes, what do you say?
Yes, sir. Yes, Your Lordship, we have been negotiating, we have been discussing, my lord. If further time can be given, possibly, my
Very well.
friend is also.
Because on 29th, this paragraph was provided by Mr. Amit to me, where he mentioned
Like the
that
previous
plan
order.
is, yes, kindly, my lord.
Of September 29, 2023, the state says that there is still room for a negotiated settlement and the parties should be afforded more time, full stop, paragraph. In view of such submission, the parties are requested to resolve the issue once and for all, since the matter has been hanging fire for several years, full stop. Paragraph. The state will file a report indicating the progress made when the matter appears next, 6 weeks hence, full stop. Every endeavor has to be made to ensure that the issues are resolved in course of this calendar year. Yes.
Deployment. In fact, the last
Obliged.
WhatsApp message when my learned friend sent, it was mentioned the layout plan, but layout plan was not there. I requested, he is supplying me. So you will definitely do it.
Please supply the layout plan that you indicated last time.
Yes, Your Lordship, I'll do that.
Yes.
So kind, so obliged.
Item number 5.
Please, my lords.
Yes.
My lords, I appear for the petitioners on item number 5, my lords. I'm being led by Mr. Jishnu Saha, my lords, who is in a personal difficulty to him, my lords.
Yes.
If I may request short accommodation, my lords.
Yes.
So time
Where
for
are we, Mr. Khan, on
number
the...
5 here.
Lord, Lordship,
Just second, Mr. Banerjee.
pursuant to the order of 29
Yes.
2003, Lordship, we had filed an affidavit, Your Lordship.
You filed an affidavit,
And Lordship, the relevant part is page, para 2.
para 2. What is the date of the affidavit, Mr. Khan?
The date of
19th of September.
19th September, Lordship. The Lordship had given them chance to respond to this affidavit.
Yes. Paragraph 2. Very well. Pursuant to the previous order.
May I just make one submission? My lord?
Yes, Mr. Banerjee.
My lord, I was requesting. My
We are
lord,
not
this,
hearing the matter. We are acceding to the request for adjournment, but we are just recording that this affidavit has been filed. Otherwise, we are not doing
Yeah, my lord,
anything.
no, my lord, only thing because my lord, this affidavit actually says my lord, they'll require 6 weeks. My lord, from 15th September. I was my lord, requesting because this percentage was really my lord, had to be fixed. My lord, if it could be done my lord, earlier, then my lord, perhaps my lord, we could have had it my lord, before the side of my lord, the court's vacation. My lord, I leave it
We don't
entirely
have
up to
any
my lord,
vacation
my lord,
here.
because it's a,
The vacation over here is in December.
no, my lord, well, my lord, before my lord, the 19th, I'm told my lord, there's a holiday my lord, or at least my lord, for
Yes. No, we'll have it that side.
Lord,
We'll have it that side. Can't have it this side of that,
My
Puja.
lords, my lords, may I
We'll
request
only
for a
just
short-
indicate that this is been filed, and then we'll record the request for adjournment and we'll adjourn the matter.
My lords, if I
my
may,
lord, this is only the fixing of the percentage. We also wanted a percentage to be fixed. My lord,
Yes.
to recall, my lord, this is that CBW, my
Very
lord,
well.
we will also my lord, be my lord,
My
Very
lords, if
well.
I may, my lords, by way of the previous order, my lords had already recorded that the affidavit has been filed. And my lords, if we just need to address the affidavit, my lords, it does not address any of our concerns raised by way of the writ
Whatever,
petition.
whatever. We are not saying that. We are just saying what the state has done because we passed an order and we are just recording whether that has been complied with. Whether that's adequate or not is not something that we are writing about.
Obliged.
Adequacy or
My lords,
inadequacy will be adjudicated later. Pursuant to the previous direction, comma, the state has filed an affidavit, full stop. Paragraph 2 of the affidavit indicates that by notification of September 15, 2023, a technical committee to examine the extent of fixing reasonable compensation or profit margin has been published. Full stop. Paragraph. Since the petitioner seek an accommodation, comma, let the matter appear 6 weeks hence, full stop. It will be open to the petitioners and also the central bonded warehouse to deal with the state's affidavit, full stop. The such affidavits, comma, if any, should be filed and should be served and filed at least a week before the adjourned date.
Very much.
my lords, my humbly request a shorter date, my lords.
Yes?
Humbly request a shorter date, my lords, not 6 weeks, 4 weeks, the most, my lords, if possible.
Thank you. Call on the next matter, please.
Obliged.
Item number 7.
You have to start from the beginning because this is what Vijayji was not there. Judgment to the paper. Zero vision and all. Ah. Is it too tatari? Yes.
That is not. My lord, this is a case pertaining to seizure of ganja mill. The date of incident is 21st March 2009.
Date of seizure is
21st March 2009. 21/3/2009.
yes.
My lord, this was a period when Shillong bypass was not ready, my lord, and the trucks used to ply through the city, my lord. So based on the source information, the officers of Custom Department, my lord, laid a trap near Barik Point, my lord.
One track.
One truck, my lord. At around 1 a.m. midnight, my lord,
Yes.
the truck was apprehended at Barik Point, my lord. And after that, the truck was driven by the truck driver himself, escorted by a customs officer to the customs office, my lord.
Which is at the corner of Keating Road.
Yes, my lord.
Then
So, my lord, upon rummaging the truck, my lord, 18 packets containing 511 kg of ganja,
Yes.
10 packets were seized, recovered from driver's cabin, and 8 packets were recovered from roof of the driver's cabin. My lord.
Outside roof,
On the top of,
on top, outside roof, not inside,
outside, my lord.
outside, yes.
Must be the open space. My lord. My lord, thereafter, sampling and seizure formalities were completed, my lord. The samples were sent to Forensic Science Laboratory. That has been proved in the court, my lord.
Samples positive.
My lord, for ganja, my lord. So, my lord, in our case, my lord, 3 essential facts which we are required to prove, my lord, in NDPS matter. Seizure from possession of the accused person, my lord. The fact that the seized article is a contraband, my lord. And third, that it is a commercial quantity, my lord.
Possession, contraband,
And quantity,
commercial quantity.
my lord.
All established.
And the fourth aspect is procedural due process, my lord, as provided under the Act, my lord.
Yes.
My lord, the learned trial court, in its judgment, my lord, has given a finding, my lord. One aspect was that when sampling was done, my lord, the samples were not drawn from all 18 packets, my lord. Samples were drawn only from 4 packets, my lord. Those were numbered as 5, 9, 12, and 16. 5, 9, 12, and 16, my lord.
Very good.
So that is one ground taken by the learned trial court. Second ground taken is, Your Lordships, on the last occasion, Your Lordship expressed your Lordship's opinion also that the matter of sunset and sunrise, my lord.
That is under what provision? Section
42, my lord.
42.
Section 42,
Not complied with.
not complied with. Not complied with in the sense, my lord, the search and seizure was carried out after sunset, before sunrise, without recording reasons, my lord.
Yes, but and this was source information. It was not a chance
This was
recovery.
information, my lord.
It was not a chance recovery.
Yes, my lord.
Give us the act, please.
My lord, one very important aspect that has not been gone into by the trial court, my lord, maybe that goes against me, my lord, but to be, my lord, section 52 of the of the NDPS Act, my lord, provides that after seizure, my lord, the sampling has to be done before the magistrate. This provision was there since 1981. 1989, my lord. It was introduced by way of an amendment in 1989. But this was interpreted in the case of Mohanlal, my lord, by the Honorable Supreme Court. Because there are two views, my lord. Because 52A deals with destruction of seized contraband, because it again recirculates in the market, my lord, because of theft and other things, my lord. So the Honorable Supreme Court took cognizance of this aspect of the matter in Mohanlal's case, my lord, and held that as soon as seizure is done, an application is to be made under section 52A before the magistrate, and samples have to be drawn before the magistrate, sealed in front of magistrate, my lord. And after that, the actual consignment of narcotics has to be destroyed, my lord. It should not be stored, my lord. And that certificate by the magistrate will be a primary evidence for the purpose of trial, my lord. So, my lord, there was a lack of clarity whether this sampling was only for the purpose of destruction or it was a mandatory procedure for search and seizure itself, my lord. Now, in 2016, my lord, in Mohanlal's case, and followed by another decision, very recent decision of Supreme Court has said that if 52A is not complied with, if sampling is not done before magistrate, it casts a serious doubt over the entire process, my lord. So, my lord, in this case, in admitted position, that sampling was not done before the magistrate, my lord.
That's 52A.
52A. But this aspect was not neither argued, my lord, before the trial court, and there is no finding to that effect, my lord.
Additional point in favor of the defense.
Yes.
Now, my lord, coming back to section 41, 42, and 43, my lord, if I may take your lordship, my lord, 41 speaks about warrant from magistrate, my lord, the first part of that, and second part talks about authorization by the empowered officer, my lord. My lord, if that is there, then that officer has the power to search and seizure, my lord. Section 42 comes in, my lord. It says that when without warrant or without authorization by the empowered officer, search and seizure can be done, my lord. So 41 deals with when there is a proper empowerment or a warrant. 42 deals with when there is no warrant or no authorization, my lord. Now 42 in its proviso says, my lord,
Second proviso.
my lord. Subsection 1, second proviso.
Yes.
Now, my lord, next section 43 talks about power of seizure and arrest in public place, my lord.
Yes.
My lord, section 43, there is no such restriction as to sunset and sunrise, my lord. So, my lord, basically what is for your lordship's consideration is the interplay between 42 and 43, my lord. My lord, if I may just take your lordship to the proviso, my lord, second proviso. It says, my lord, few words I'll just try to stress upon, my lord.
Yes.
Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of it, he may enter in such building, conveyance, or enclosed place, my lord. These three words are used together, my lord. At any time between sunset and sunrise after recording the grounds of his belief. Now, my lord, the conveyance word is used in section 42 also and section 43 also, my lord.
Yes.
So when conveyance is used in section 42, my lord, the sunset sunrise clause applies, my lord. But when conveyance is under section 43, that clause is not applicable, my lord. My lord, on this aspect, my lord, though I was trying to locate some Supreme Court decisions, is not available, my lord. But Punjab and Haryana High Court, in two decisions, my lord, if lords is permitted to place,
Yes.
they have tried to clarify, my lord, trying to read these three words in proviso, ejusdem generis, my lord.
Is?
Ejusdem generis, my lord.
Ejusdem generis.
My lord.
Where?
The building, conveyance, or enclosed place, my lord, used in proviso in section 42, my lord.
Further, if such officer is reason to believe that a search warrant cannot be obtained without affording opportunity or consumer, he may enter and search
Building, conveyance, or enclosed place.
Yes.
So these three words have been read in a particular sense, my lord.
Yes.
Vis-a-vis the word used, conveyance used in section 43, my lord. Because 43 is about public place, my lord.
Don't follow what you're saying.
My lord, section 43, the heading itself says, my lord, power of search and arrest in public place, my lord.
Yes.
Now, public place, it defines, my lord, conveyance is also included in public place, my lord, in the definition of public place.
That's a
The explanation, my lord, section 43.
in the explanation, that's an open definition, that's not exhaustive. It is not exhaustive. For the purpose of this section, the public place includes.
Any public
So
conveyance,
it may include something more also,
my lord.
but it at least specifically includes these.
My lord, we are concerned with conveyance. Conveyance is specifically
Okay.
mentioned, my lord.
It will also be a water body. It will also be a tank. It will be a pond, even though it is not referred to over here.
My lord. Possible, my lord.
Because the explanation is not exhaustive.
Inclusive.
It is only inclusive.
My lord.
Now, how can you compare an explanation with a proviso?
Hello, what I'm trying to submit, my lord. My lord, broadly speaking, my lord, 42 talks about building enclosed space or a conveyance. So conveyance word used there, my lord, will be a stationary vehicle may be parked inside somebody's residence, my lord, or in somebody's compound, my lord.
Yes, can also be.
My lord. Whereas section 43 visualizes a situation when a public transport or public vehicle is moving on the road or is in any public place, my lord.
Yes.
So that is the distinction sought to be drawn by the Punjab and Haryana High Court, my lord.
No, but if you see this, See, one has to read it in conjunction with 42.1.
My lord.
42.1, the operative part is, first is description of the person, then if you have the same book, look at the third line at page 32, overleaf, third line. First is description of the person.
My lord.
If he has reason to believe from persons, knowledge or information given by any person and taken down in writing,
Yes, my lord.
so that is the first precondition.
My lord.
In that scenario, this proviso operates.
My lord, in that
In
scenario,
42,
if there is a source information,
that is not there. In 42, that information from someone
my lord.
reducing that information into writing is not there.
In 43 is not there, my lord.
In 43, it's not there.
Well.
In 42, it is there.
My lord.
So in 42, provided this is there, the proviso will be attracted.
My lord.
In your case, 42.1 has been complied with.
My lord.
Once 42.1 has been complied with, the proviso is attracted. There is no question of going to 43. 43 is a situation where otherwise than from information received,
My lord.
the concerned officer has reason to believe. Say he is stopped a car because there is a high VIP movement and there is a checkpoint. So he has stopped a car at the checkpoint. And then he suddenly gets smell of weed from the car. Based on that, he says, open up, let me check you. The distinction is the prior information. Because he has prior information, the exercise that he is conducting under 42 is planned. The exercise that he conducts under 43 is unplanned.
My lord.
And you cannot compare the two.
My lord, where the planned and unplanned, there is some vanishing line, my lord, is because planned can be scrupulously planned if something is static, my lord. For example, the examples are given building or enclosed space. A conveyance that in my observation is used in that case, my
You
lord.
cannot mix up 42 and 43. They are completely different subsets, operate in different fields. They don't coincide even for anything.
Because
They
what
don't
will happen,
overlap.
because what will happen, my lord, even Punjab High Court has said that, my lord, but this will be an unpragmatic approach because we do not know the exact timing, what time the truck will cross Shillong, my lord. We only have the information that the truck has been loaded with so much of ganja from somewhere, maybe Tripura or Manipur, my lord, and is crossing Shillong.
Very well. So therefore, you get that information,
My lord.
you record that,
My lord.
that's the kind of the general diary entry that you make,
My lord.
and you embark.
My lord,
You embark on the mission.
my lord.
Now there, you cannot comply with, between sunset to sundown, if those conditions you not comply with, look at 40, the proviso.
Record the reasons.
Reason believe that such cannot be obtained without affording opportunity concealment. He may enter such and such enclosed at any time after recording the grounds of his belief.
My lord.
And then the difficulty comes in two. So you record the grounds of belief, so they say that it is approaching fast,
My lord.
or we do not know where it is.
My lord.
It might be there anytime on you.
My lord.
So while he records the GD entry, of that information that he records, he will also write this, and then he proceeds. All that is required to do is that recording he must furnish to his superior officer in terms of 42(2) within the next 72 hours.
My lord. My lord, that part has been complied with in this case, my lord.
Which one?
Information to the superior senior officer. my
No,
lord.
no, no.
Only the recording of reason is missing, my lord.
Exactly. Both have to be there. If you have time to do the GD entry, And if you think that this is there, write it in short. No one is asking you to write Mahabharata over it.
My lord, the difficulty, my lord, in this case, it was apprehended at 1 o'clock midnight, my lord. If it was 5 o'clock, my lord,
When did you receive the information?
page 23. Page number 23. On 20th March at 4:30 a.m., my lord.
20th March, 4:30 a.m.
My lord.
So you had almost 24 hours.
Almost 24 hours. my lord.
Almost 24 hours. And does it disclose the source or from where? Nothing.
No.
So you had 24 hours. A lot of time. That's a long time.
Because practically what will happen, my lord, because the customs officer
We
do not know.
understand what will happen, but the law is draconian. It gives no relief to the accused. So if the procedure for seizure is not complied with, then it's as if no seizure is made from the accused. That's the consequence of that. One can understand, Mr. Dr. Mudika, that you are at a checkpost, you are customs.
My lord.
You are looking for contraband in the sense that goods which are dutiable and are being got into without paying duty. Goods which are prohibited are being got in. You are looking for that. You are not looking for illicit material. In course of that, there is chance recovery, yes. That is the distinction between 42 and 43. In 42, you have information. You can plan it out, you can plan out, you can have 2 minutes to plan it out, you can have 2 days to plan it out, you can have 2 hours to plan it out. But the moment you have time to plan it out and you have time to also record it, if you apprehend that you may not be given enough time to strictly comply, you have to record that also. And that recording must subsequently, then it gives you complete independence. Do it at your leisure. After having done all this, take rest, sleep, have 3 good meals. Within 72 hours, you send it to your superior official. It gives you that much latitude. Whereas the other one requires nothing, because in the other one, you don't know.
But
You kind of, let's say, jokingly poke the punch of the driver. How do you have such a punch? And you poke him, suddenly drugs fall out. That is something which is a chance recovery, for which no preparation is required to be made. 42, 43, and 43 will have no impact. What do you mean by aeusdem generis?
because conveyance word is used
What
in
does aeusdem generis mean? Aeusdem generis means they have to be seen in the same light.
same light, my lord.
Similarly,
So conveyance in this is something
so if it
stationary.
conveys in the same light in 43, that will be confined to 43. How can that impact 42? You read them aeusdem generis, yes. But that will be confined to the 43 situation. You can't transport it to a 42 situation.
Well, that is where I could only locate
There's no tax on saying nonsense.
Punjab and Haryana, my lord.
There's no tax on saying nonsense, so therefore we'll take that into account. We'll say it's rubbish.
My lord, that is a view taken by Punjab, Haryana, my lord. Once it is public place, 42, even recording of region is not necessary, or recording of satisfaction is also not necessary. My lord.
No.
They read of section 43.
42 makes no distinction between public place or not. The distinction between 42 and 43 is whether you have prior information. When you have prior information, when you are doing it at a public place or anywhere else does not matter. The distinction between the two is prior information, not the nature of the location. It can be from a public place.
Because proviso deals only with location, my lord.
Which one?
The proviso talks about
But the
location.
section deals with that. You can't read the proviso divorce of the substantive provision. The proviso qualifies the substantive provision. You can't divorce it from that.
It's true.
Let's say the substantive provision says that every father of a child in school will have to wear a cap. Let's say the proviso says, provided that if the father is more than 70 years old, he has to wear the cap upside down. But it qualifies the substantive provision. It cannot mean any father. It means the father of a son going to that school. So you can't compare the proviso to some other provision. It proviso qualifies the provision. It either highlights what to be done, without an exception, or imposes another condition, or maybe clarificatory. These are the uses of a proviso: to emphasize, to accept, to clarify. Over here, the proviso says that in a particular situation, this must be done. You can't import anything from 43 into 42.
That is the view taken by one High Court, my lord. I could come across only two decisions of Punjab and High Court. My lord.
Yes. And is there anything in the Act which says that, this procedure has to be followed or whatever? Is there any such provision?
My lord, but the power to stop and search conveyance is also there in section 49, my lord.
49. Any authorized officer under section of me is confined to animal or conveyance.
Animal or conveyance.
Is animal or conveyance. Confined only to animal or conveyance. And reason to suspect does not have to be prior information.
My lord.
It will be a 43 kind of scenario. It's in addition to 43. 49 is in addition to 43. Can never be in addition to 42. Let us say that a particular, let's say, kind of drug, if consumed, emits yellow flames. He has seen yellow flame, and therefore he has reason to believe. Then he stops, whether it's an animal or conveyance. Animal over here is animal used for the purpose of conveyance, because camels are used as mules for this.
Right.
Originally, mules were used as
Right.
for ferrying. So any kind of conveyance, anything that moves, horses, cattle, anything.
But I'm only looking at the larger issue, my lord. No, without confining to this particular case, my lord.
Requires it to be done in a particular manner. It's the same. King Emperor Nazir Ahmed.
But the practical difficulty, my lord, even in this case, my lord, they have to wait on the roadside for hours, my lord. From day, suddenly it becomes evening and then nighttime, my lord. The daytime scenario will be different, my lord, and nighttime after sunset, the scenario will be different.
Yes. Therefore, the lawmakers perceive that in the daytime, you cannot plant all this easily because there will be people walking around. But in a nighttime scenario, you carry it on your person, no one else can see, you plant it, and you say, I'm recovered.
Because what might happen, my lord, at night time, if the officer, instead of stopping the truck and apprehending it, my lord, that sometimes by use of force, and if he has to comply these kind of formalities, my lord, that he has to first record the reason, then only he can stop the truck.
No, but he has to record a reason. If the moment he receives information, he has to record a reason.
My lord, the recording of reason will come only if the apprehension is at the night time, my lord, after sunset and before sunrise.
No. Look at 42.1.
My lord, there are two aspects of recording of
If
reason.
he has reason to believe from persons, knowledge or information given by any person and taken down in writing.
My lord.
So therefore, that taking down in writing is a condition precedent to the provision operating.
My lord.
So therefore, let us say he received a phone call or a little boy has run and said that, look, this is happening. He's heard that and reduced in writing. It's just an extra line that he has to write after that. All that you're saying becomes irrelevant.
My lord, what I'm trying to submit, my lord, there are two stages of recording reason, my lord. One is at the time of recording source information, my lord. There he has to record reason, my lord. Second, in proviso, it talks about that it cannot be waited till next morning, my lord. For that, he has to record a separate reason, my lord.
So therefore, there's a little boy who calls
My lord.
and says that I live next door. In my place, a car is about to leave, which will cross in front of your police station in the next 10 seconds. All right? In such a scenario, he cannot write the information part of it also.
Right.
He cannot write the other one.
Well,
So he doesn't do either. 43 happens. It's as if that he casually stopped it and found it. But when he has the time to record in terms of 42.1, there can be no excuse for not recording what is required under second proviso. He has the pen, he has the ink, he has the paper, he has the time. It requires another 5, 10 seconds, 1 minute, 2 minutes, 3 hours more. It's infinite units of time. There cannot be any excuse for recording the first part and not the second.
so my lord, I thought of placing, but that is what the Punjab High Court has said, my lord.
You place it, we have to also put our view out so that others are discouraged from following that. You will also show us what our trial court says on this aspect.
The first one, my lord, para 4.
Paragraph 4. Oh, there are 2 or 3 judgments.
One is from Supreme Court, my lord, and 2 are from Punjab Haryana High Court.
Then show us Supreme Court. If Supreme Court says this
My
can be
lord,
done.
the only difficulty in the Supreme Court decision is a very short decision, my lord, and here it is not clear whether it was a source information or not.
So the first judgment that you're showing is that is flag C.
Flag A is the Supreme Court, my lord.
Yes, so we'll start with that.
My lord.
2006 9 SCC 170. Yes.
Para 4.
Para?
4. Turning now to section 42.
Yes. No, nothing is.
This is not clear whether there was a source information or not.
The other one?
Flag B, my lord, para 10, 11.
Flag B. That's also.
Punjab Haryana.
That's Punjab and Haryana. 2002 SCC online Haryana 762. Yes.
Not para 10, my lord.
Yes.
May I read, my lord? Para 10 onwards.
What were the facts over here? Was there prior information?
There was a prior information, my lord. Para 2, my lord. But the time duration was very short, my lord.
That's it. Please come to paragraph 2, just above paragraph 3. The two principal guys ran away. The driver and cleaner were apprehended. They did not want to be examined by a gazetted officer or magistrate. Then, their statements, exhibits PD and PE in this respect were recorded it has been further mentioned in the RUCA that the DSP could not be contacted, but on the directions and in the presence of station house officer, ASI Bhagmal conducted a search. What does the proviso require? The proviso requires the reason for not doing so being recorded, and within 3 days thereafter being communicated to the immediate superior official. Here ASI contacted the SHO and on the direction of the SHO and in the presence of the SHO conducted the search. So 42 proviso is complied with. 43 is not necessary. The court completely misdirected itself.
My lord, the second proviso talks about recording reasons before, my lord, and thereafter carrying out the search and seizure.
Recording reasons before and thereafter carrying out, and
Informing with 72 hours, my lord.
2, those recording reasons are not to be sent to a museum. Why recording reasons? So that 2 can be complied with. Within 72 hours thereafter you send it. Over here, he had done better. He had called the superior officer, the superior officer had come down, and at the direction of the superior officer, he conducted the search in his presence. There is substantial compliance with 42.
But judgment is not relying on those facts.
That is not, the court misdirected itself. See over here how it goes wrong. Come to paragraph 7. First argument is that there is violation 42. Bhagmal has received, but he did not record his reasons of belief of commission, nor he disclosed the said information to superior officers as contemplated under 42.2. It is the such requirement of 42.2 are mandatory. Non-compliance will render the prosecution vitiated. That's the issue.
Well,
As we see substantial compliance, then the court goes on to a completely wrong premise in paragraph 10, as if 42, 43 and 49 are similar situations. 42 is based on information, 43 is not information and public place, 49 is animal or conveyance, no information. This distinction is lost in paragraph 10 between 42 and 43. And this distinction has come out in several Supreme Court judgments that they are completely different situations, can't be compared.
well.
So this is Corinthian. Yes, and what is C?
Well, C is also in similar line, my lord. Para 19 is only relevant for it.
Two 2004. Paragraph 19.
19.
Come to paragraph 2. Come to paragraph 2. As per prosecution allegations, on 24/11/1999, Inspector so-and-so, along with ASI so-and-so, ASI so-and-so, and ASI so-and-so, and other police officials were present in front of bus stand in connection with general patrolling and checking of suspected persons. At about 6:40, Kishan Lal, son of so-and-so, also went to police body, he was also associated. At that time, received a secret information to the effect that
This is a scenario, Lordship.
Just a second.
My lord. It's a 25 minutes only, my lord. 6:40 and 7:05.
See the mistake in paragraph 19. Section 42 contemplates entry and search of any building, while 43 is either made in a public place. No. The distinction appears to be in the information received. Chance recovery can only be in public place. Chance recovery can't be in a specific house. And you cannot have reason to believe and enter a house thinking that there could be prostitution, thinking that there could be drugs over there. That would require some kind of information to be received for having reason to believe. And that is the entire distinction between 42 and 43. 42 and 43 are not different places. The nature of the place is not the distinction. The nature of the place is also distinction because unless you have information, you will not want to go into a house or building or to search. It's only if you have information will you want to do that. Let's say you're just an officer standing and having a conversation with a friend. But you're an authorized officer. Suddenly an auto rickshaw comes and stops. Or the auto rickshaw gets down and you see his eyes are bloodshot red. And when he was traveling right up to there, he was, wavering and not in control. By virtue of your position and by virtue of what you have seen, you may have reason to believe that he's just consumed or is in possession. That is a 43 situation. But there's a building, many people coming at the balconies, you can see people in the windows. You can't just enter that building thinking that I have reason to believe. Anything else? How has the trial court dealt with the aspect?
Well, but in para 16, my lord, the trial court has dealt with this aspect. Para 16 of the judgment at internal page 14.
Page?
Internal page 14, my lord.
Internal page?
14, 1-4.
This is the paper book.
Paper book will be page 183, my lord.
180?
187, sorry. 187.
187.
Para 16 of the judgment.
What is the section 55 story?
Well, section 55 is that the seized articles have to send to nearest police station. Well,
Yes.
but our case is that this is a customs case, my lord. So police officers, the police station doesn't come into picture, my lord. And in that regard, I've referred to some reasons, my lord. But your lordship, since you're deciding on that major issue, my lord, Because we will be covered by section 52 3B, my lord, not by 55. That is because it is investigated by customs, my lord.
$52.
3 subsection clause B, my lord.
জিজ্ঞেস করবো জিজ্ঞেস করবে
May it please your lordship. In gist, your lordship, the case is that the appellant received the information on 20th March 2009 that one truck has left Silchar at about 4:30 a.m. your lordship. On 20th March 2009 at 4:30 a.m. the information was received by the IO cum complainant. The IO complainant and information received by the same person, PWA, your lordship here. Then 4 persons, they went and they were waiting for the truck. On 21st morning, about 1 o'clock, the truck was traced. It was taken into custody and brought to Kitting Road behind the custom office. Prior to that, the information was reduced in writing, and it was communicated to immediate superior officer also. While apprehending the truck and unloading the contraband, your lordship, there were no gazetted officers, no authorization under section 41 was taken, though they got almost more than 21 hours, and they would have taken the search warrant under subsection 1 of 41, or the authorization from the gazetted officer under subsection 2 of 41. But here it has not been done in this case.
Show us subsection 2 of 41.
Talks about the magistrate, your lordship, that empowered magistrate can issue the search warrant. And subsection 2 of 41 says that any such officer of gazetted rank of the Department of Central Excise, Narcotics, Customs, Revenue, Intelligence, or any other department of the central government, including the paramilitary forces or the armed forces, as is empowered in this behalf.
Yes.
So this 41 has not been done.
No. Read 41.
Yes, your lordship. Empowered in this behalf by general or special order by the central government or any such officer of the revenue, drugs control, excise, police, or any other department of a state government as is empowered in this behalf by general or special order of the state government, if he has reason to believe from personal knowledge or information given by any person and taken in writing that any person has committed an offence punishable under this act, or that any narcotic drug or psychotropic substance or controlled substance in respect of which any offence under this act has been committed, or any document or other article which may furnish evidence of the commission of such offence, or any illegally acquired property, or any document or other article which may furnish evidence of holding any illegal acquired property which is liable for seizure or freezing or forfeiture under chapter 5A of this act, is kept or concealed in any building, conveyance or place, may authorize any officer subordinate to him but superior in rank to a peon, sipahi or a constable to arrest such a person or search a building, conveyance or place, whether by day or by night, or himself arrest such a person or such a building, conveyance or place.
Ordinarily, our officers in charge of police stations, are they empowered?
Officer in charge?
Of police station?
Officer in charge, not a gazetted officer, your lordship.
Is not?
No, no, lordship.
He is not empowered.
Inspector, officer in charge normally is a inspector, your lordship.
Yes.
So inspector does not come under the gazetted officer, your lordship.
So it's a gazetted officer who must be empowered.
Empowered, your lordship. Then thereafter, your lordship,
But under 42(2),
your lordship,
a sub-inspector may get permission from an inspector.
but here talking about the gazetted officer, your lordship.
A general special order.
(42) begins with any such officer. Superior in rank to peon, sepoy and constable. So, ASI is superior.
ASI, yes, your lordship.
ASI may not be gazetted, SI also may not be gazetted.
No, they can search, your lordship. ASI, SI or inspector, they can search after getting authorization from a gazetted officer under 41, your lordship.
Yes. No, but in 42(2),
Yes, your lordship.
where an officer takes down information, under subsection 1, or records his belief under the proviso thereto, he shall be to his immediate superior, to his immediate official superior.
Yes, your lordship.
So who will be the official superior of an ASI?
Inspector, your lordship.
Or a SI is a sub-inspector.
Yes.
Image will be an inspector.
Yes, your lordship.
That inspector may not be a gazetted officer in terms of 42(2).
Yes, your lordship.
Yes.
Then thereafter, your lordship, the truck was brought to Keating Road and it was parked. The items were unloaded and kept in the custom office. 3 persons were apprehended, respondent 1, 2, along with one driver, which is as per appellant, your lordship, the driver at 5 o'clock, he ran away from their custody and till date not traceable. So that is another case. And here, your lordship, the learned my senior has said that this case will come under 43 and not 42. Your lordship has rightly came to the conclusion that...
No, that's all right. Anything else that we haven't said? Anything else that you want us to know?
Here, your lordship, that 42 has not been complied. It has not been reduced in writing, and it has been admitted by the PW8.
Yes, that we have seen. That we have seen.
That I have not complied with
Very, yes.
41 and 42, your lordship.
Huh? The third question that arises in this appeal is as to the effect of the admitted non-compliance with the condition laid down in the second proviso to section 42 of the Narcotic Drugs and Psychotropic Substances Act 1895 and the impact of such non-compliance on the seizures. Full stop. Paragraph. By the judgmental order impugned, stated
Page 175. 22nd February 2011.
February 22, 2008, 2011, the two accused persons were acquitted by the trial court primarily on the ground that the sanctity of the seizures of contraband could not be accepted, and on an incidental ground that Section 55 of the said Act had also not been complied with. Full stop. Paragraph. The Union, through the Narcotics Control Bureau,
Customs.
the Union through the Customs Department, is an appeal, since it was a customs official who had made the alleged recovery. Full stop. According to the Union, there was substantial compliance with the relevant provision and in any event, since the recovery was made from a vehicle in a public place, the trial court ought to have read the situation in the light of Section 43 of the said Act instead of Section 42 thereof. Full stop. As to the incidental ground indicated in the impugned judgment pertaining to Section 55 of the said Act, the Union claims that such provision would have no manner of operation, since the seizure in this case was not by the police but by customs authorities. Full stop. The Union submits that the appropriate provision in this case, instead of Section 55 of the Act, would have been Section 52 bracket 3 bracket B thereof. However, the Union contends that in the light of the bigger issue as to whether the conditions precedent to the applicability of Section 42 of the Act were complied with, being the more important aspect of the matter, it is only upon the Union succeeding on such aspect will it be necessary to go into the incidental aspect comma, whether under section 55 or under section 53 bracket 52 bracket 3 bracket B of the Act. Full stop. It is, comma, thus, comma, that the matter is taken up for consideration, comma, primarily as to whether it was necessary to comply with section 42 of the Act or the conditions precedent to its application, semicolon, or comma, whether by virtue of section 43 of the Act, comma, the strict rigors of section 42 of the Act need not have been adhered to. Full stop. Sections 42 and 43 of the said Act have to be seen in the context of section 41 thereof and as distinct situations which are exceptions to the rule which is recognized in section 41 of the Act. Full stop. Section 41 of the Act is the first provision in chapter 5 of the said Act. The relevant chapter covers section 41 to 68 and for 41 to 68 and is intituled within inverted commas capital P procedures. Such chapter is followed by an entire chapter which has been incorporated by amendment and covers forfeiture or illegally acquired property. Forfeiture or illegally acquired property. Full stop. Section 41 of the Act recognizes the power to issue warrant and authorization. Full stop. A warrant and authorization, comma, inter alia for arrests and for the search, comma, whether by day or by night, of any building, conveyance or place comma, in certain circumstances. Paragraph. Section 41(1) of the Act authorizes a metropolitan magistrate or a magistrate of the first class or any magistrate of the second class specially empowered by the state government to issue a warrant, full stop, warrant, comma, where the purpose for issuance of the warrant is for arrest of any person whom such magistrate has reason to believe to have committed any offence punishable under the Act, or for the search, comma, or for the search, not comma, of any building, conveyance or place in which such magistrate has reason to believe that any narcotic drug or psychotropic substance or controlled substance in respect of which an offence punishable under this Act has been committed full stop. This search can be by day or by night, pursuant to such authorization, full stop. In addition, comma, the search authorized by such provision may pertain to any document or other article which may furnish evidence of the commission of any offence under the Act or any illegally acquired property and may also relate to any article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5A of the Act. Full stop. Paragraph. Subsection 2 of Section 41 of the Act confers similar authority on a gazetted officer, comma, whether of the central government or of the state government, comma, and from various departments, as long as such official is empowered in such behalf by a special or general order by the appropriate government. Full stop. Paragraph. Section 41(3) of the Act give authority to the officer in whose favor a warrant under Section 42(1) is issued, or authority under Section 42(2) is conferred, to have all the powers of an officer acting under section 42 of the Act. Paragraph. It is now necessary to see the entirety of section 42 of the Act and even refer to section 43 thereof, since certain judgments have been cited on behalf of the Union, which, on the face of it, appear to have confused as to the efficacy of as to the applicability of section 42 and 43 of the Act, and have quite erroneously use the two provisions as interchangeable. Full stop. Set out section 42, set out section 43. Paragraph. Section 42 of the Act permits any officer above the rank of peon, sepoy or constable of state and central governments, if empowered in such regard by the appropriate government by any general or special order, open quote, if he has reason to believe from persons knowledge or information given by any person and taken down in writing close quote, that any material that any substance, not material, any substance in respect of which an offence punishable under the Act has been committed, or any document or other article which may furnish such evidence, or any illegally acquired property, or any document or other article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing or forfeiture under Chapter 5, capital A of the Act, is kept concealed in any building, conveyance or enclosed place. Semicolon, then for such official to be entitled to undertake the acts and activities enumerated in clauses A, B, C, and D of the subsection, comma, provided that such act or activity is conducted between sunrise and sunset. Full stop. For the present discussion, paragraph. The first proviso to subsection 42(1) is not relevant. Full stop. The second proviso to subsection 1, as to section 42 bracket 1 of the Act, wherever I say section or whatever, it has to be of the Act. Section 42(1) of the Act. The second proviso to section 42(1) of the Act has carved out an exception from the substantive provision by indicating the special procedure to be followed if the search or the like is to be conducted between sunset and sunrise. Full stop. The additional requirement, comma, in such a scenario is that the concerned official should have recorded the grounds of his belief as to why such as to why a search warrant or authorization, comma, in accordance with section 41 of the Act, comma, could not have been obtained without compromising the purpose of the exercise. Full stop. In other words, comma, as long as an official above the rank of peon, constable, peon, sepoy or constable is empowered generally or specially to carry out a search under the Act, comma, such person would have the authority to do the things indicated in clauses A to D of section 41(1) or 42(1) of the Act. During the period of daylight hours between sunrise and sunset, comma, upon receiving information from which he has reason to believe that any offence under the Act has been committed, or such information pertains to anything which ought to be confiscated anything that ought to be seized or frozen or forfeited under Chapter 5, capital A of the Act. Full stop. As long as the relevant person is empowered, comma, as long as such person records the information received and there is reason to believe the same, and as long as any of the activities indicated in clauses A to D of section 42(1) of the Act is to be conducted by such official between sunrise and sunset, comma, he can go ahead and do the same. Full stop. However, comma, paragraph, however, comma, if the activities indicated in clauses A to D of section 42 bracket 1 of the Act were to be undertaken at a time not between sunrise and sunset, but between sunset and sunrise, comma, the additional duty cast upon the relevant official is to record reasons of his belief that unless such was conducted at such hour, comma, the purpose of the exercise would be defeated or the evidence would be lost. Full stop. Paragraph. There is a further duty cast on the concerned officials referred to in the immediate preceding paragraphs. Such official is free to do all that he is otherwise empowered under section 42(1) of the Act. Also at a time between sunset and sunrise, as long as he complies with the second proviso, section 42(1) of the Act, and comma, in addition, comma, within 72 hours after conducting the exercise, such official is required to forward whatever he was required to record in writing to his immediate superior official. To his immediate official superior. To his immediate official superior. Full stop. Paragraph. It is evident, comma, therefore, comma, on a plain reading of the relevant provision that it is only when some information is received by an authorized official, by an empowered official, that he can enter into any building, conveyance or enclosed place between sunrise and sunset for the purpose of searching or seizing or arresting without warrant or authorization in terms of section 41 of the Act. Full stop. By virtue of the second proviso to section 42(1) of the Act, he is further empowered to do all such activities between sunrise and sunset, between sunset and sunrise, only upon recording his belief or reasons as to why it is imperative so to do. Full stop. The only additional requirement is to communicate such special reasons within 72 hours of conducting the relevant exercise. Full stop. Paragraph. In a manner of speaking, comma, the strict requirements under section 41 of the Act are diluted to meet the exigencies of the situation if a scenario in terms of section 42(1) arises and it leaves a small window of time to take action. Full stop. Further, comma, the additional restriction between sunset and sunrise has also been removed upon a suitable condition in respect thereof being provided by virtue of the second proviso to section 42(1) of the Act and the safeguard in section 42(2) thereof. Full stop. Paragraph. Now to turn to section 43 of the Act. Full stop. There is no doubt that section 43 of the Act and even section 49 of the Act that comes later, comma, are an exception to the general rule in section 41 of the Act, just as section 42 is another species of exception to the general rule in section 41 of the Act. Full stop. However, comma, section 42 of the Act can never be mixed up with section 43 of the Act, though section 43 and section 49 of the Act may be somewhat of a similar nature. Full stop. Paragraph. On the one hand, comma, section 42 of the Act envisages information being received, but contemplates that despite receipt of such information, there may not be enough time to either obtain a warrant or obtain an authorization in terms of section 41 of the Act. Full stop. In such a scenario, an empowered officer is permitted to go ahead and do whatever he could have done upon obtaining a warrant or an authorization under Section 41 of the Act, provided that the search or other activity that he undertakes is within daylight hours between sunrise and sunset. Full stop. The legislature then contemplated that there could also be a scenario where it was necessary to intervene during night hours or between sunset and sunrise, as the time available may not be sufficient to comply, sufficient to obtain either a warrant or an authorization in terms of Section 41 of the Act. Accordingly, the legislature added an additional condition in such regards to the other condition already included in Section 41(1) of the Act. Full stop. As long as in a such or like activity being conducted between sunrise and sunset, the information the fact that information has been received is recorded. That the fact that information has been received that leads to a reason to believe is recorded, the empowered official has all the authority as if he was supported either by a warrant or by an authorization in terms of Section 41 of the Act. Full stop. Where such or other activity has perforce to be conducted between between sunset and sunrise, or else the evidence would be lost, upon recording the additional reasons, the search or other activity may be conducted by the empowered official without obtaining any warrant or authorization, as long as all the reasons are forwarded within 72 hours of the exercise, forwarded, exercise, to the immediate official superior of the empowered official. Full stop. Section 43 of the Act is not based on any information being received as to any offence under the Act having been committed, or as to any thing that may be seized or frozen or forfeited under Section 5A, under Chapter 5A of the Act, or pertaining to any illegally acquired property in terms of the Act. But in essence, Section 43 of the Act covers what is come to be known as a chance recovery. Full stop. When officials undertake checking activities, comma, whether looking for an escaped convict or for extremists or for illegal arms or in course of security operations pertaining to any high official, comma, incidentally come across any material incidentally come across any narcotic drug or psychotropic substance or controlled substance in respect of which he has reason to believe that an offence under the Act has been committed, comma, he may proceed to detain and search any person whom he has reason to believe to have committed the offence and also has the authority to recover anything contraband from any person's possession. Full stop. Section 49 of the Act extends the similar provision to any animal or vehicle which is used to ferry contraband. Full stop. Paragraph. The distinction between the scenarios covered by Section 42 of the Act and Section 43 thereof is obvious, colon. In the first, comma, the concerned official has some reason to believe of any offence having been committed and there is likelihood of discovery of material to substantiate the suspicion. Full stop. In the second case, there is no suspicion as to the commission of any offence under the Act. Full stop. It is only in course of conducting another activity that a concerned official has reason to believe, comma, incidentally, of the commission of an offence under the Act of 1985, that Section 43 or Section 49 of the Act is triggered off. Full stop. The two distinct situations covered by the distinctly worded provisions of Section 42 and Section 43 of the Act cannot be mixed, cannot be seen in the same light or even compared. Full stop. Paragraph. Indeed, the very kind of places indicated in section 42 and the kind of places indicated in section 43 of the Act show the extent of distinction sought to be made by the legislature in such regard. Full stop. No one would have or ought to have any reason to enter into any building or like place unless there is an element of suspicion, element of reasonable suspicion. Full stop. The number of places covered by section 42 has been extended to conveyance, in addition to building, and has generally been kept open, without being exhaustive, in the use of the word place within quote at the end. Full stop. But the suspicion has to be there. And the place can even be a packet left hanging from somewhere. As long as there is some reason to believe based on information in such regard. Full stop. Section 43 of the Act, however, is extended to public places since the general screening or combing, C-O-M-B-I-N-G, general screening or combing or scrutiny would be conducted in a public place and may, generally, not involve entering into a building or the like. Full stop. Thus, the larger sense that the word conveyance conveys both in section 42 and in section 43 of the Act would include vehicles. Full stop. But in terms of section 42 of the Act, the vehicle could be parked inside a building, inside any premises, or within a garage, and there may be information of some contraband therein. Full stop. In the section 43 scenario, however, This can never be. As the vehicle has to be in a public place and must have been stopped in the usual course of the checking or the combing operation undertaken by the authorities or the concerned official. Full stop. Paragraph. In short, comma, nothing in section 42 of the Act can take color from anything contained in section 43 thereof, and vice versa. Full stop. It is elementary that there is a cardinal principle that when a law requires a certain thing to be done in a certain manner, comma, such thing has to be done in such manner or not at all. Full stop. The rule attaches with greater force when there are harsh consequences for committing a particular act. Full stop. In such a case, comma, when the procedure established by a particular provision in the relevant statute requires adherence thereto, comma, the failure to comply with the relevant conditions will entail failure to comply will free the accused of the harsh consequences of the statute. Full stop. Paragraph. There are several provisions in the Act of 1985 that would require strict compliance. Full stop. The search and seizure provisions would require a degree of seriousness to be attached thereto. Full stop. The Act recognizes that since the activity of producing, manufacturing and transporting drugs is generally clandestine, comma, any delay in taking steps may result in the delayed step being futile. It is for such purpose that the rule has been enunciated in section 41 of the Act. Before the general exigency has been recognized in section 42 thereof, and a special exigency in the second proviso to section 42(1) of the Act, and comma, as a consequence, comma, the rule in section 41 of the Act has been relaxed. Full stop. There is also a purpose for providing a different provision as in section 43 of the Act, for an accidental or chance recovery which is not based on any prior information or suspicion or reason to believe in the commission of an offence under the Act. Full stop. Even the rigors under section 42 of the Act, even the limited rigors under section 42 of the Act, thus, stand relaxed and are absent from a scenario covered by section 43 of the Act. Full stop. But that does not mean, paragraph, that the two provisions are interchangeable and when a recovery is made from a vehicle, the fact that previous information may or may not have been available is irrelevant. Full stop. That would make a mockery of the statute and the relevant provisions. There is a clear distinction in what is to be done upon information being received and upon having reason to suspect an offence under the Act having been committed, and in a situation where there is no such reason to believe or harbor any suspicion in such regard. Full stop. In a sense, section 43 of the Act, along with section 49 thereof, is the residuary provision pertaining to the rule in section 41 of the Act. Such residuary provision cannot be resorted to, as is the cardinal principle in statutory interpretation, when there is a specific provision in such regard. Full stop. In the present case, it is the admitted position that information pertaining to a particular truck carrying drugs was received by the concerned customs official, who examined himself as PW8 at the trial, at 4:30 a.m. on March 20, 2009. The information received was that the truck had or was about to leave Silchar at that time. Full stop. Such customs official, who was otherwise empowered under section 42 of the Act, proceeded to record in writing the information that he received, which information that he received, full stop. However, at the trial, such official candidly and unreservedly admitted that though the relevant truck was apprehended at or about 1 a.m. on March 21, 2009, he had not recorded his reasons for proceeding with the search between sunset and sunrise without seeking any warrant or authorization or run the risk of missing the truck altogether. Full stop. Paragraph. Once so much is admitted that the search was conducted between sunset and sunrise, and the additional condition required in the second proviso to section 42(1) of the Act was not complied with, the entire search operation would be suspect and would be otherwise than in accordance with law and, consequently, vitiated. Full stop. As a result of the concerned official not complying with the additional condition in the second proviso to section 42(1) of the Act, there was no vetting of such reason in terms of section 42(2) of the Act by any immediate official superior. Full stop. Paragraph. Since the general rule as to search and seizure is recorded in section 41 of the Act, and an exception is carved out therefrom in section 42(1) thereof, the exception would be limited to all that is covered by section 42(1) thereof and nothing beyond. Full stop. When a further exception, in addition to the general exception under section 42(1) of the Act, is made out, in the application of the general rule recognized in section 41 of the Act, and a condition imposed for such further exception to apply, the non-adherence to the condition would not permit the additional exception, would not permit the provision as to the additional exception to be availed of. Full stop. This is elementary in interpreting the effect of a statute and its provisions. Full stop. Paragraph. The circumstances which revealed themselves at the trial rightly attracted the attention of the court. Full stop. The trial court was justified in coming to a conclusion that since the condition precedent to the additional exception envisaged by the second proviso to section 42 the second proviso to section 42 bracket 1 of the Act had not been complied with, comma, the concerned official had no authority to undertake the search or any related exercise. Full stop. In the absence of such authority and the statutory bars as a consequence of section 41 of the Act, comma, all that followed had to be regarded as irrelevant. Full stop. Paragraph. It is in such circumstances that the union submits that if the union's contention on substantial compliance with section 42 of the Act is not upheld, comma, the further ground under section 55 of the Act would not be required to be looked into. Full stop. Paragraph. In addition, comma, the union fairly submits, comma, as it is expected of such litigant, comma, that though the trial court overlooked the matter, comma, it is also the admitted position that section 52 capital A of the Act was also not complied with in the present case. Full stop. Paragraph. The union has referred to 3 judgments in support of its contention that when it was a vehicle that was being searched and such search was conducted in a public place, comma, the strict conditions under section 42(1) of the Act, under section 42 of the Act, would not apply. Full stop. Paragraph. In the first of such cases, in the first of the cases cited, comma, reported at 2006 bracket 9 SCC 170 bracket Union of India versus Major Singh, comma, there is the following paragraph 4 from the report which is placed, colon, set out paragraph 4. Paragraph. However, comma, the relevant order cited runs into just about a page and spills over 5 paragraphs without the basic facts being revealed therein. Full stop. It is not indicated in the report whether the relevant case was one based on information received as to the commission of offence or was a case of chance recovery only. Full stop. Paragraph. Accordingly, comma, the dictum, comma, so to say, may not be read so wide as canvassed by the appellants, comma, in the absence of the relevant facts being evident. Full stop. Paragraph. A Punjab and Haryana judgment has next been brought by the union, which is reported at 2002 SCC Online PNH 762 bracket Dharminder Kumar versus State of Punjab. Paragraph. Full stop. The facts in such case are recorded at paragraph 2 of the report. Full stop. In that case, some secret information was received and within a short time of the receipt of the information, the vehicle carrying the contraband was apprehended and the offending material recovered therefrom. Full stop. An argument was made that section 42(2) of the Act had not been complied with in that case, though it is not evident as to whether was not complied, was not complied with in that case, full stop. Upon noticing such contention, the division bench of the High Court referred to both section 42 and 43 of the Act before recording as follows at paragraph 10 thereof, set out paragraph 10, paragraph. With respect, the judgment failed to see the distinction between the scenario covered by section 42 of the Act and the completely different circumstances in which section 43 of the Act would operate. Full stop. Despite it being evident that this was a case where secret information had been received as to the particular vehicle, merely because the search was conducted in a public place, the High Court erroneously applied section 43 of the Act when such provision had no manner of application in the case. As indicated earlier, section 42 of the Act covers a situation where a search is conducted upon a reason to believe that an offence under the Act has been committed pursuant to information in such regard being received. Full stop. On the other hand, section 43 of the Act comes into play when the object of the search is something quite removed from the 1985 Act and, incidentally, in course of the search, there is reason for the searching official to believe that an offence under the 1985 Act may have been committed. Full stop. Paragraph. Full stop. Since the two provisions, as indicated more fully here and above, operate in two distinct situations, the view expressed in section 10 or in paragraph 10 of the report is found exceptionable and does not appeal. Full stop. Paragraph. In the final of, in the last of the precedents cited, comma, it was a similar, it was also a case covered by Section 42 of the Act. Full stop. Though the ratio of the judgment is found at paragraph 19 thereof, and there is a comparison of section 42 and 43, though it is a comparison between apples and oranges, comma, the end result, comma, however erroneously arrived, comma, may be justified on the facts indicated in paragraph 2 of the report. Full stop. However, comma, to the extent that sections 42 and 43 of the Act have been put on the same pedestal and compared inter se, comma, such approach is, comma, with respect, comma, found to be erroneous and contrary to the purposes and objects of the two distinct sections and the areas of their operation. Full stop. Paragraph. For the reasons aforesaid, comma, the mistake committed by the relevant customs official in this case of not adhering to the condition indicated in the second proviso to section 42 of the Act has to be regarded as fatal. Full stop. No such or like activity could have been conducted by such official between sunset and sunrise without complying with the condition precedent as indicated in the relevant proviso and the condition subsequent as mandated in section 42(2) of the Act. Full stop. Since the very search in this case was erroneous, comma, however much the quantity of seizure may be claimed to be, comma, such argument of prejudice cannot influence the court. Full stop. Paragraph. The appellant claims that the seizure in this case was of 18 packets containing a total of 511 kg of ganja. Full stop. The only silver lining may be in such ganja, comma, if it is assumed to have been recovered, comma, may have been dealt with in accordance with law and taken off the streets. Full stop. However, comma, upon the procedure for search not being followed in terms of section 42 of the Act, which is an exception to the general rule in section 41 thereof, comma, the prosecution case has been rightly rejected by the trial court, full stop. The reasons indicated in such regard in the impugned judgment do not call for any interference. Paragraph appeal number so-and-so is dismissed. If there is any interlocutory application, dispose of the same. Paragraph. There is a line which needs to be added as to the delay in the disposal of this matter, particularly since there can be little excuse in this High Court, comma, at least, of a criminal appeal waiting for 10 years. Full stop. Recent orders would indicate that more often than not, it was the appellant which was shying from court and not prepared to proceed with the appeal. Full stop. At other times, comma, it may have been the allegation of the quantum that may have prompted the court to look at the matter more seriously than if in an ordinary case, section 42(2) of the Act, section 42 of the Act had not been complied with. Full stop. That's it.
But the matter was delayed because it was kept in abeyance because of pendency of a matter in Supreme Court. My lord.
When was that? Till when to when?
Many years, my lord. For 5 to 6 years, it was pending.
Then there's very good reason.
So, Fansing's judgment.
Then just cut this out and say that a line of explanation has to be furnished as to why this matter remained pending for nearly 12 years. Full stop. You have to give me the time when till which is the judgment.
Noted to Fansing case.
So when was
the question came up in this matter, my lord, whether the statement recorded by custom officer is admissible in evidence or not. And that was pending before Supreme Court in Tufan Singh's case.
Very well. One of the questions that came up in the appeal was whether a statement recorded by a customs official was admissible in evidence, and as such the matter was kept pending till the judgment in Tufan Singh. I'll give you the reference, I have that. Tufan Singh is italics, was delivered, full stop. Even thereafter, the appellants took time over the last few months to proceed with the matter, particularly considering the serious quantum of recovery that was allegedly made and the consequence of what may have been an error on the part of the official. Full stop.
Fansing case 2021, volume 4, SCC, page 1.
Thank you. I think we've dealt with all aspects.
Only the last sentence, my lord. Probably only one date, my lord.
That is true.
That was the only one date, my lord.
No, several. All right. Because to one thing, I've cut it. After that, cut it out.
I have no personal interest, my lord. Only one particular day, my lord, I had to leave, my lord.
Look at the order sheet, you'll realize it's more than that. Anyway.
Kindly.
Item number 8.
Maybe please your lordship. Your lordship, that non-receipt of the copies, that question I raised.
Non-receipt of the?
Copies. This is the case that the son was hacked by the husband.
Yes.
And later on she
So
wanted
what is the non-receipt of the?
copies, relevant copies of the trial, at the time of trial,
Yes.
under 207.
Are you seeking an adjournment?
I have examined your lordship. It
Are you
says that
seeking an adjournment? If you seek an adjournment, we'll grant you. He didn't even want to do the last one, but had to do it because it was a 2011 matter.
yes, lordship, as your lordship. Yes.
No, I don't wish. I wish to do it. If you want to do it, I'll do it. I'm paid to do it.
Lordship seems very exhausted.
No, I am not exhausted at all. I'm not paid to be exhausted.
Lordship,
Let's do it. Let's finish it. Yes.
can we after break, your lordship?
No, we don't want to take a break because he'll have another bench to go to. And we don't see that you were engaged for the last few hours.
No, I'm not. No. Obviously not.
Up to your lordship.
No, for us, we can just take it and finish it.
Maybe tomorrow.
Tomorrow, lordship.
Instead of tomorrow, today is better.
Yes.
Yes. Tell us what the matter is about.
Lordship, the matter is with regard to the death of the husband. First, in fact, the husband wanted to get a divorce from the wife, and since the wife refused.
Oh, the two children who were thing.
Yes, Lordship. That's the case.
Very well. Since the appellant seeks time, let the matter appear later in the week. Put it that way, give it next week.
Deeply obliged.
I hope that was the last dictation I've had to give in court.